Let's jump right into this, shall we? Welcome to The Explainer. Today we're stepping into the pretty complex arena of South African civil court procedures. Look, whether you're a law student cramming for exams, a candidate attorney, or honestly just someone fascinated by how the legal machine actually works, navigating this stuff absolutely requires a playbook. So, let's see if we can piece a solid one together right now from the source material. So it all starts with one wildly fundamental, incredibly practical question. How do you actually ask a court for something? I mean, it sounds super simple, right? But the second you decide you want to approach a judge, you hit this huge fork-in-the-road decision. Make the right choice, and your case gets moving. But make the wrong one, your case is literally dead on arrival before a judge even glances at your argument. No pressure. All right, here is our game plan for today. First up, actions versus applications. Second, the uncontested short form. Third, the standard combat long form. Number 4, we'll hit urgent and interlocutory applications. And finally, number 5, those golden rules and fatal errors. Let's get into it. Section 1, actions versus applications. Or, as I like to think of it, choosing your arena. So, looking at these two paths, there is a super sharp distinction in South African civil law. Over on one side, you've got an action. You kick this off with a summons, it's the whole shebang, a full-blown trial. You've got people taking the stand, lawyers aggressively cross-examining witnesses, real courtroom drama. But then, on the other side, you have an application. And applications are a totally different beast. Generally speaking, nobody is taking the stand. The entire case is decided on written affidavits. It's basically a massive paper trail of sworn statements. And instead of a summons, you start an application with one very specific document. Which brings us straight to the star of the show, the notice of motion. This document is your absolute essential opening move. It literally tells the court and whoever you're going up against exactly what it is you want. But more than that, it officially puts them on notice and says, hey, here's your chance to fight back. It essentially dictates the entire rhythm of the application. But here's the catch. Not all notices of motion are created equal. Let's break that down. Moving on to Section 2, the uncontested short form. This is basically the no-fight route. All right, so this is known as Form 2. You take this route when things are, peaceful. You're pretty certain nobody is going to oppose your request, or maybe there's literally just nobody else involved to fight against. Because there's no opponent pushing back at you, this form is addressed exclusively to the registrar or the clerk of the court. You're pretty much just handing your sworn affidavit over to court administration and saying, hey court, here's what I need, and here's my sworn statement explaining why. Can we grab a date for a hearing? Easy enough. But when exactly do you actually use this? Well, the short form is perfect for ex parte applications. Now, that's just a fancy Latin way of saying you are the only party standing in front of the judge. Think about really personal legal stuff. Like, say you and your spouse mutually agree to change your matrimonial property system. Or maybe you're asking the court to appoint a curator for a relative who just can't manage their own affairs anymore. It's also your go-to for completely friendly, totally undisputed matters. You just need the court's official stamp of approval. You don't need them to referee a boxing match. But as we all know, things aren't always so friendly. Section 3, the standard combat long form. Welcome to the battleground. Meet Form 2A. You are pulling this one out when there is a very clear other party involved. We call them the respondent. You fully expect that they're going to push back, dig their heels in, and fight your request. And because you're anticipating a brawl, the tactic changes completely. This form has to be addressed to both the court and the respondent directly. This is your standard combat route for serious contested stuff. We're talking demanding a company hands over their internal documents, filing for an interdict, or legally forcing someone to finally honor a contract they've been dodging. And this brings us to the strict rules of the game, which are actually built right into the form itself. Because you're literally dragging an opponent into court, the law says, hey, you have to give them a fair shot to respond. You absolutely cannot just ambush them. So the long form explicitly includes a countdown clock that you, the applicant, have to spell out for them. All right, rule number 1. Once your respondent actually receives this long-form notice, the clock starts. They have exactly 5 days, just 5 days to make a major strategic decision. Are they going to fight this? Because if they are, they have to formally file a notice of intention to oppose. And then, right after those 5 days, rule number 2 kicks into gear. The respondent then gets 15 days to get their side of the story down on paper. This is when they draft and file their answering affidavit. They lay out all their evidence, all their counterarguments, right there in writing. So it's 5 days to say, yeah, I'm fighting, and then 15 days to basically throw their first punch on paper.
Okay, but what if you literally don't have 5 and 15 days to wait around? Section 4. Urgent and interlocutory applications. These are basically your special moves.
Look, the long and short forms are great. They're the foundation. But the real world, it doesn't always play nicely with standard court timelines. That's where these variations come in. Urgent applications are exactly what they sound like. They let you completely skip the standard motion court dates and bypass that whole countdown clock we just talked about. You do this because waiting around would cause irreparable harm. But here is the catch. You absolutely must justify that urgency in your affidavit. You have to prove to the judge exactly why you can't just wait in the normal line like everybody else. Now, on the flip side, we have interlocutory applications. These are basically mini applications that happen inside a lawsuit that's already underway. Because everyone is already in court fighting anyway, this one just uses a slightly tweaked version of the short form.
Let's put that into perspective with a real-world stakes check. You're firing off an urgent application when, say, there is a literal wrecking ball parked outside your client's historic building, and you need a judge to halt the demolition by tomorrow morning. You don't have 20 days. You have like 12 hours. On the other hand, you use an interlocutory application for something a little less dramatic, but honestly, just as frustrating. Like when your opponent is being super annoying, totally dodging your questions in an ongoing trial, and you just need a quick court order to force them to answer. Which brings us to our final stop. Section 5. Golden Rules and Fatal Errors. Surviving the game. Okay, if you're cramming for exams or you're out there working in practice, you really want to lean in for this part, because picking the wrong form will completely destroy your case. Take a look at this matrix. We've got the short form 2 on top. That's your ex parte or unopposed stuff, addressed only to the registrar. Right below it, the long form 2A, your opposed matters, addressed to both the registrar and the respondent. Getting the primary use case and the audience right is crucial, but guys, it is this final column right here that you absolutely need to burn into your memory. Let's talk about the fatal flaw of the short form. Imagine you try to take that easy, no-fight route. You file a short form, but secretly. You know full well that a third party actually has a direct interest in the matter. Well, that is going to blow up in your face. The court is going to see that someone who legally deserved a say was totally left out. In the legal world, we call this non-joinder, failing to join an interested party to the case. And the consequence? It's brutal. The judge won't even bother reading your arguments. They'll just throw your entire application out. Game over. You lose. Okay, but what about the long form? Its fatal error is entirely procedural. Remember those strict rules of the game, the 5 days and the 15 days? If you draft a long-form notice of motion and you just forget to type in those standard deadline clauses, your notice is technically defective. You've completely failed to properly warn the respondent of their rights, and believe me, their lawyer is going to spot that typo immediately. They'll point it out to the judge, and your entire notice can be completely set aside. Imagine losing before you even start, just because you missed a single paragraph of text.
And honestly, that is exactly why mastering these forms is so incredibly critical. You've seen the difference between the peaceful path and standard combat. You know how to deploy those special moves when the clock is ticking, and you know exactly which fatal errors will get you thrown out of court before the fight even begins. So I'll leave you with one final, very real question to think about. You know the rules now, but will your application actually survive the court? Definitely keep that in mind the next time you're drafting your opening move. Thanks so much for joining me on this explainer, and keep learning.